short ride.
Yes, Mr. Panton.
Well, my lord, I need to begin by correcting sort of inadvertently misleading position in relation to how D3's position on the law has been in the context of the case. It was implied, at least, that D3's position on duty of care had changed on the appeal. A concession had been run for D3 in that regard. Whereas, in fact, D3's position has been quite consistent. D3 has indicated from the outset that it accepts that the duty of care could attach in relation to instruction. And it's quite important just to make this clear, because it sets the context for the judge's findings in relation to D3. So if I just may very briefly take the lordships to the third defendant's skeleton argument below the application.
Yeah, where do we find that?
232.
Of the core bundle, is that?
It's in a supplementary bundle, but I think that is all part of the same core bundle, I think. 232.
Yes.
And your lordship sees that there's the identification of the four reported courses of action, three of which were dealt with very quickly. So occupiers liability disposed of by one reference, section 41 disposed of quickly, negligence in the stowing sense disposed of quickly, and then fourth and finally, negligence, construction, design of the carriageway. D3 accepted then, as it accepts now, in principle, a highway authority can be liable and cites what Lord Hoffman said in Gorringe about creating danger. And D3's complaint then, and is now, is that the pleadings do not come anywhere near establishing what they would need to establish, or saying what they would need to say to get that case off the proverbial ground. I got a paragraph reference wrong, and I said 19D. Of course, it's 20D, where I noted that there was this reference to this memorandum.
Sorry, where are you?
I'm so sorry, I'm still in my first instance skeleton.
Yes.
Page 235.
Yep.
So, paragraph 11, I've made clear we accepted the existence of this duty. Then I said, below that, even assuming D3 constructed a highway, which that assumption has always been made, no pleading or evidence establishes duty at that time to install signs, vehicle restraint barriers, etc. Such pleading as there is the design of highway is hopelessly vague and unparticularised. I should have said 20D.
I see.
Yes, I'm so sorry. Yes, refers loosely to a memorandum in relation to road design, suggests radius of berm is significantly less than absolute minimum, doesn't even trouble to identify what the prescribed radius is, what the radius of the actually is, and then I made some further points in relation to the particulars. So the point was always, these particulars are inadequate even to get the case started, recognising that there is this duty of care. Just pausing there for a moment, I summarise it this way. What the claimant has to establish in order to succeed against D3 is that no reasonable highway authority in 1967 would have created that bend or failed to erect crash barriers. That's the nub of the case. And in the heart, which of course is the barriers case, Mr. Justice Moreland actually went so far as to say that that involves a Boland test. And I'll take you, if I may, your lordship's familiar with the facts apart from yesterday's submissions, of course. If we could go to Authorities Bundle 199, please.
Yes.
Paragraph 34. There wasn't any evidence before his lordship as to whether there had been judgment exercise, discretion exercise at the time of construction in 1974 in that case. prepared to assume that there must have been, he's already dealt with that by the time he gets to this paragraph. He says, assuming it's right for me to infer there was an exercise of judgment as to the length of the approach safety fence in 74 by professional highway and bridge designers and engineers, I agree with the department, the highway authority, submission that the Bowden criteria apply. The fact that Hart's expert Hodgson would have had the fence's length longer does not establish professional judgment made in 1974 was negligent. They needed 7 metres more safety fence on the bridge at Great Heck to have prevented settling. 10 people wouldn't have died if they had 7 metres extra fence. There's the analysis, the way that the analysis proceeded in Hart was not what one might call the standard common law breach analysis, magnitude of risk, magnitude of harm, cost of preventive measures, social policy considerations, and whatnot. I'm not saying it would have gone the other way if that had been the way the analysis proceeded, but one would have thought the insurers would have had a stronger case in that regard. All you needed to do was have an extra 7 metres of fence. But it's not that sort of analysis, it's a Bowden test. So that sets the context for analysis of the particulars of the claim in this case. And when we look at this, I now invite you, I know you'll have been several times, but just to really focus in on what is said in the particulars in relation to these critical issues. I'll come back to barriers, but I'll start with bend. And so this is 20D, page 81 in the core bundle. So cause then will permit the highway to be designed and constructed with a radius on the bend which was significantly less than the absolute minimum. With respect, the kindest thing that can be said about that is that it's vague. And significantly in breach of contract, in a contract claim, would be struck out. Significantly in breach of statutory duty, in an ordinary personal injury claim, would be struck out. I mean, one sort of keep going on. Just saying significantly means nothing with the greatest possible respect. And Mr. Weir seemed to think it faintly ridiculous that anyone would want to know, well, sorry, how sharp is this bend and how sharp should it have been? What is the differential? I seem to think that was some sort of arcane issue. That's the heart of the case, because it must be shown that that differential created the risk of injury, or in the shorthand parlance, created danger. And I accept entirely what Mr. Weir says about the use of the word danger tends to be shorthand for a longer way of putting it, creating a foreseeable risk of injury and that sort of thing. But it must be shown that the differential is dangerous, and on causation, the claimant would have to prove that that differential, not just the bend, but the difference between how sharp it is and how sharp they say it should have been, that caused the fatal loss of control. And so when I said below, respectfully, there are not even the beginnings of a coherent case on this point, with respect, I was right, and there's no real answer to that in my respectful submission. This is hopelessly vague.
Can I just ask you this? I mean, those are proper points that sound as if they would be made when you're analysing a pleading and requiring further information. They don't necessarily strike me, perhaps rightly or wrongly, as a sort of points that you would strike out a pleading for. And I noticed that in the pre-action correspondence, it was said, you haven't even raised this, we'll have to go back and see what the design parameters were. And if you're going for reverse summary judgment, which I well understand in the light of your saying, well, you've given us no particulars, you haven't exhibited what the standard was, they haven't, and so we're just stuck with the pleading.
Yes, and the point about pre-action correspondence was in my defence. Essentially, I made 2 points there, and not in a what I would say sort of an aggressive way, in the sense that I didn't say you haven't raised this before, so you're going to have to be struck out. I said you haven't raised this before, so you can't expect us to give you chapter and verse. In fact, at the moment, we can't even confirm that we built it. And secondly, I went on to then say, by the way, what you have not referenced standards at all in relation to barriers. And although you have mentioned this standard in relation to them, you haven't put anything like enough detail. I'm paraphrasing the defence.
Yeah.
You haven't put enough detail. So that is a very clear warning shot across the bows. Look, you can't. Your first three courses of action are, with the greatest respect, utter nonsense, and you should know that. On this, you need to focus, and you need to plead what you know you're going to need to plead if you're going to succeed. Now that's enough. We don't then have to follow that up with a Part 18 request. And actually, in many ways, stepping back, it's quite unusual for this sort of issue to reach the strikeout stage, because what tends to happen, what one would generally expect, is you get the amended particulars, or you get the correspondence saying, look, we're sorry, but we have, speaking honestly, we haven't bottomed this out either, that's why we're raising it now, we haven't got to the bottom of this ourselves, give us 6 weeks, give us a month, and we will provide you with amended particulars, or here is our expert evidence, which shows that we have a case here, and so, look, do you really want us to amend, because this is all a bit isn't necessary. You get a response. You don't get nothing. You don't get the claimant just rocking up at the strikeout hearing and saying, "Oh, this is fine," which is essentially what's being done. I mean, in relation to barriers, of course, the difficulty becomes even more acute because of Hart. Because Hart, as your lordships have been taken to some but not all of the standards that were cited in Hart. And I appreciate Mr. Weir said he wasn't relying on them, at least against D1 and D2. I'll just come to that in a moment. Hart shows you, if nothing else, that this area, safety barriers on roads, is an area where standards have applied for many, many years. And just the only reason I want to just get your lordships to look at the standards again is because I wouldn't want you to be left with a misleading impression as to what they said. And just to take you back very briefly to what was said in Hart about standards, which is page 194. Mr. Weir took you through the early stages of paragraph 18, so I won't repeat that. We start with TD 19/85, which is mainly concerned with technicalities about different types of barrier. You then, he talked about BE5, paragraph 19, which he described as the important standard then. He then talked about technical memorandum H973, which also applied at the time to 1974 construction in Hart. And noted that it said safety fences are normally recommended in those circumstances. Then there was the 1968 manual, which essentially we looked at, but he said he wasn't going to rely on that, at least against D1 and D2, he said. He didn't take you on to the next paragraph. Earlier circular to Divisional Road Engineers 23/60, guard fences. It's now been agreed that at points of special hazard, guard fences may be provided. Paragraph 4, guard fences may also be used at points of special danger, etc. So I'm not taking you to that to try and establish what the standards were for the time of construction. My point is that it would be wrong to proceed as if there was some very, very clear and obvious standard at the time, represented by the 68 memo or anything else, that said you had to have safety fences at this sort of location. So insofar as that sort of implication was left hanging claim submission, it would be wrong. So, standards govern this area of construction, have done since 1960 at the latest, not a breath of a reference to standards in the particulars of the claim. And indeed, I've made this point in the skeleton. You have to remember that the judge, of course, is reading the entirety of the particulars. He's not given any clear express concession of the hopeless causes of action. And so the causes of action have included occupiers liability, Highways Act, and the sort of general statutory power means you have a duty argument. for all he knows, the allegations made in relation to barriers are allegations made under the Occupiers Liability Act. But now it's all very clear and it's all very concise. Mr. Weir has got hold of the case and said, no, we're focusing it right down to this one sustainable duty of care. Then now it's all very clear. It wasn't. And if you plead, and again, without wanting to repeat myself, when the defence has said in big letters, you have not pleaded standards in relation to barriers, it is very odd, to say the least, to just turn up at the strikeout hearing without even mentioning the point. And so when you turn to what Judge Gore said, and there's two separate sections of the judgment where he says exactly the same thing. Pages 67. And 69. You get this identical text. In this case, neither is it alleged, nor is it evidence, that what the highway authority created, pausing there, he's plainly alive to the allegations about what we created. He knows exactly what's being alleged. What the highway authority created, open brackets, the sharpness of the bend, close brackets, either was dangerous in itself or that it caused this accident. And he's not, with great respect, he's not making some sort of finding that there is no duty of care. He is accurately, pithily describing the state of the particular claim in this case. Now, could he have spent more time on it? Absolutely. Would some judges have, forgive my mind interrupting my lord.
No. Sorry, I interrupted you. I thought you finished. I was just going to ask you a question. What you finished? You were saying he could have been more explicit, but
absolutely, he could have spent more time on the point. Of course he could. But in his defence, he was having to hack through a lot of issues as against D3, including 3 nonsensical causes of action. And you can see from the other parts of the judgment we've already been taken to that he was dealing with them as well. He was dealing with Section 1, he was dealing with so on. So, of course, he could have said more. But the end result is the same. You have not pleaded enough. I would say what he's saying is you have not said there is a danger or that the danger causes accident.
can I just deal with the causation point? Because if you look at the pleadings, in conventional terms, it pleads the accident. And then if you go to paragraph 19, which you identify as that's first and second defendant. No, don't worry. And then 20, it says further, and in the alternative, it was caused by the negligence and or breach of statutory duty of the highway authority. So the accident was caused, and then it does say, little d, constructing it with a radius which was significantly less than the absolute minimum. So if one goes back to 67, is it right for the judge to have said, albeit cryptically as you fairly identify, that they haven't pleaded, they haven't alleged that it was caused by that?
Well, my reading of that is that what he's very probably referring to is paragraph 6, because that was the point I had made in the skeleton. And the point which struck me as a matter of real concern, and again something which had to be flagged up for the claim. Because paragraph 6, as yours should rightly says, pleads the circumstances of the accident. But all it says is that she lost control of her vehicle where there was a sweeping left-hand bend. That is all it says. Now, if there was a sustainable case that the loss of control was due to what I call the differential.
Too sharp a bend.
Too sharp. So that the difference between it, the bend as it is and the bend as it should have been, if that was actually the claimant's case, and if that was in any way a sustainable allegation, would that not appear in paragraph 6? And this may be part of what Mr. Weir is describing as the sort of even obvious, his words, not mine. Yeah. But it doesn't seem to me that that is a terribly esoteric.
You say that paragraph 20 is not enough to plead causation.
I can see that it's. Yeah, well, no, I'm not saying that. he does say that the breach caused the accident.
Yes.
But
What more does a pleading need to say?
well, in respect of the cause of the accident, in respect of why the accident happened, where the pleading is describing the circumstances of what happened, the pleading should set out what caused the loss of control in the vehicle. That's what I'm saying. So the point
Well,
is,
yes, that's true, no doubt, but we're not marking somebody's homework. We're seeing whether the pleading discloses the minimum necessary to get this case to trial.
well, let me put it this way. In paragraph 20D, there is no clarity of what the complaint is or what the...
Well, that bit I understand.
So,
You're now talking about causation, which is a different point.
So how, if there is no identification of that, how can it be sensibly said that causation is properly pleaded? There is, you're right, there is the general wording at the start of the paragraph that is causal or materially contributed by all of these various breaches, A to M, that are alleged. But there isn't any apparent recognition that what is needed is not just a vague allegation of breach in a general causation paragraph, but specificity that was caused by the differential. That's my concern.
Yeah.
I mean, I agree, for what it's worth, I agree with the weird dictum on pleading, which I wrote down. You need to plead sufficient information, and after that it becomes stylistic choice. I agree with that. My complaints are not of style. My complaints are of substance. The first limb of the weird dictum is vital. You have to plead sufficient information to set out what the breach is and that it caused the accident. That wasn't done. So the judge, I would respectfully suggest, for all his brevity, was entitled to reach that conclusion. And this, taking a step back, the case against D3, it isn't an occupiers liability case. It's a construction dispute, actually, more than anything else. It's about alleged negligent construction by the standards of now 54, then 53, well, they exceeded 53 years ago. How can such a case get off the ground with you were significantly in breach of this, and, well, you should have put up a barrier, but we can't say why. This is, with the greatest possible respect, this is a hopeless basis for that sort of course of action. And recognising that is no more than what the judge did. So that you haven't pleaded what you need to plead. And that takes care of ground 7 of the appeal, which is the real nub of the appeal. It's a short point, really, as against D3. Grounds 8 and 9, I can deal with a little more briefly. On ground 8, I probably don't need to say much more than I did in the skeleton for the appeal, which I'll just, if I may, direct your lordships to. This is page 179. The core bundle. And the point that was made in the grounds of appeal was, well, that he's imposed a requirement on the claimant to give evidence, to produce evidence for the purposes of strikeout. But the basis for that suggestion is simply his use of that expression, neither pleaded nor evidence. There is no clear expression anywhere in the judgment that he was imposing this requirement. He did not say there is a requirement on claimants to produce evidence for strikeout applications.
No, well, you say that he said it wasn't alleged. It wasn't evidenced either, so I have to go on what's alleged.
Yeah. The way I read this is it's a tacit, as I've said in the Scotland, it's a tacit recognition that the pleading may not be great, but someone may actually put in standard evidence or an expert's report and say, look, sorry, Judge, it isn't very clear, but look, this is what we're getting at. And the judge then said, well, right, I understand. In that case, I can see how you're going to put your pleadings right, so I'm not going to hold it against you that the pleadings are defective. And the point is, he never said in terms that he was imposing this requirement. Mr. Weir is trying to extrapolate from the word neither alleged nor evidence that he imposed the requirement. Or I'm not having to work hard, as Mr. Weir said, to try and interpret that. All I'm doing is saying Mr. Weir's interpretation is necessarily tendentious and may not be right. There is an alternative explanation for the use of that wording, which I've set out there. So, I mean, it's the claimant to show that the wording has the effect that they're suggesting. And they can't. There's an equally, at least equally, possible interpretation of what he said. And ground 9, I confess I rather lost Mr. Weir here, because he seemed to be suggesting that ground 9 had fallen away because of this concession by D3 on the appeal, as he erroneously suggested, as to duty of care. So he said, well, we don't really need to look at ground 9. But actually, and this is a fairly important point, D3's position having always been as it was, so no concession having been made on appeal that wasn't made below. Looking at the judge's wording, this ground of appeal arises from his reasons for refusing permission, which are on page 71 of the full bundle. What he said in his reasons for refusing permission, ground 9 is misconceived because sharpness of bend and/or absence of a crash barrier, open brackets, features of nearly all roads in places, close brackets, do not alone constitute actionable misfeasance. And the accusation that was made in ground 9 was, oh, he's mixed up. He's categorised us as a non-feasance case, whereas in fact we're a misfeasance case. He's got the law horribly, horribly wrong, because he said that this case is something it isn't. Now, with great respect, one doesn't need to take very long to read what was said there to know that that is a very unfair, indeed one might say entirely spurious criticism, which has not, as it were, it hasn't fallen away because of some concession by D3. That was a spurious criticism right from the outset. And if it is still maintained, which I'm not sure it is, then it's unfair and it should be disregarded. So, I conclude briefly in this way. First is to deal with issues of amendment of the particulars. The judge is criticised, at least using in the written submission, paragraph 53, page 32, or, well, that's the exact wording that would be best. The court should always consider whether any pleading defect can be cured by amendment and refrain from striking out a claim without giving the claimant the opportunity to amend. No opportunity is given by the judge to amend in order to cure what a defect the judge understood there to be. Now, it seems to me that's a rather broader submission than the law has recognised, and that seems to be suggesting there's a positive duty on the court where a party is not saying we're going to amend, or we can amend, or we're very sorry we'll get this right. Where a party hasn't even asked for opportunity to amend. The court should nonetheless steam in and say, well, look, don't you want an opportunity to amend your particulars of claim? My understanding of such authority as there is on this is that where there's a real prospect that an amendment will cure the defect, where there's shown to be a real prospect of that, or where a party is saying what I've said, look, please give us a chance. Absolutely, the court should be slow to strike out a statement of text. But where a party isn't even asking the opportunity, it's a rather harsh criticism to level at the judge to say he should have volunteered. This is an adversarial justice system. So the onus is on the party to say they want permission and to say what they're going to achieve. And the key points that the claimant would need to plead and prove to succeed in the case against D3. I mean, putting it this isn't nuclear physics. I mean, all they've got to do is plead, the bend is this and it should have been that, and this is why, because this memorandum or whatever says so. And no reasonable higher authority wouldn't have put a barrier up because this standard, which applied at that time, says that's all they've got to say. They haven't got close to that. And so when there becomes quite an important point of impression, where you have particulars of claim which are advancing hopeless courses of action, which aren't seeking to delineate between which allegations arise from which one of the courses of action, and which, on the face of it, are also throwing the kitchen sink at D3 with utter vague inability to deal with grapple with the really key issues. The impression that creates is of particulars which are sort of going on, well, look, something will turn up. Look, what we need to do is we'll chuck it in there. The bend is too tight, and there should have been a barrier, and we'll see if we can get an expert to agree with us. It isn't the most impressive way to proceed. That risks strikeout. It creates a danger, very clearly, of being struck out. So then rock up at the hearing without even recognising that any of the defects there is an extraordinary approach. Bluntly and unfortunately inviting, frankly, what happened. And I concluded in this way. I didn't have the pleasure of appearing before any of your lordships as first instance judges, so I don't know how you would have approached these particulars. It may well be that you would have taken a more benevolent view that Judge Gore did. It may not. It may be that you would have expected higher standards in terms of the pleading for key points. But even if you do, in your own mind, think, well, actually, no, I would have let this go. I would have allowed this to proceed. And I would have seen how the expert evidence panned out. That doesn't mean he was wrong.
But this isn't, is it, do you say, an exercise of discretion? This is an evaluation of what is pleaded, and does it amount to a legally sound cause of action?
Well, I'm not sure I put it quite like that. I know exactly what you're saying. It's an evaluation of whether pleadings are sufficient to get what is a recognisable cause of action in the sense that people can bring claims. Is there enough to get this off the ground?
Yeah. Is
there enough for this case to move forward to disclosure, to expert evidence? Of course, at the moment, expert evidence is a bit of a mystery here, because does anyone launch a claim like this without an expert's report already to hand? I mean, is that seriously what's happened? That the claimant has fired all this off and has just got all that the information and the particulars of British duty from their own research? I don't know. It's a bit odd not to have the expert report already. If they have got it already, and that is all it says, is what they've pleaded, then they're in terrible difficulty. But leaving that aside for a moment, it is an evaluation of adequacy of pleading. It's not an evaluation of evidence, etc. But it must be an issue on which there is room for judicial disagreement of approach. I mean, there's a I suppose if I put it like this, there's a spectrum of particularity in pleadings, isn't there? And if anything, the modern tendency has become to plead too much and throw in too much evidence, too much detail. The other end of that spectrum, there is too little detail, where you haven't pleaded enough to get the case off the ground. There must be room for different judges to take a different view in the circumstances of the cases before them. There wasn't any law or any legal dispute in the case against these three. It's purely about evaluation of pleadings. So I do maintain the point. The fact that you might have taken a more benevolent view doesn't mean that he was wrong.
If one was a first instance judge, one would have required both sides to bring along the memorandum.
Not quite.
But that applies to them and you, because otherwise you end up with both sides dancing on the pinheads of a judgment and a pleading in the Court of Appeal, which is not what the civil procedure rules were designed to appreciate. You're perfectly entitled to point out that they pleaded it in a scattergun approach, but on the other hand, there are duties on both parties.
Yes, but then again, of course, the burden of proof is on the claimant. The claimant pleads and the defendant responds. So the claimant has to say, you were in breach of this standard in this way. It's just, it really is as meaningless as in a contract claim, saying the defendant was significantly in breach of clause 5 of the agreement. It really is as meaningless as that. And the onus is on them to get that right. When we then respond to it by saying, well, whatever memorandum didn't apply, or you've misread it, or no, your calculations are wrong, or whatever the response might be. Those are my submissions.
Thank you very much. Thank you. Yes, Mr. Weir, do you wish to reply?
My Lord, yes, please. Well, can I start with D3, because obviously that's fresh in your Lordship's mind. And can I start by looking at the defence? You've been taken to the skeleton argument below, and I won't rehearse what you were shown in D3's skeleton argument below. But if we look at the defence, which the court was obviously concerned with, it starts at an appeal bundle, tab 10, page 107.
170.
107, my Lord.
107, sorry.
And if the court then turns over to page 108, paragraph 2, the third defendant, as a matter of law, A isn't an occupier, B's got a statutory duty which isn't relevant, is my qualification of that. C has got other statutory duties which aren't relevant. D, his further statutory powers in relation to, amongst other things, the creation, construction, which is our case, etc., of the highways. However, the existence of such statutory powers does not give rise to a common law duty of care. That's how the case was...
To provide any particular feature. Doesn't say it doesn't give rise to a duty of care not to create a start bend. And if there was any doubt, the answer is in the skeleton.
Well, my Lord, we seem to be deep into pleading points, and I'm just going to pursue the pleading of the third defendant. It says what it says. Paragraph 8 deals, at page 110, deals with paragraphs 12 to 17, and paragraph 12 is our case that says that the third defendant constructed this highway. It says this is confusing, etc. The third defendant states the highways are uncontroversial. Down at the bottom, give rise to unspecified statutory duties and or common law duties of care. And then when you go to paragraph 12, which deals with the allegations of breach of common law duty of care at para 20, para 20 is denied. It is denied that the third defendant were negligent and on breach of that duty, whether as alleged or at all. So there we've got a denial which one would anticipate would lead to a positive case being averred in the ordinary way that it should be. What we actually then have, as you see at A and you see at D, is a generalised complaint as to how matters came late, which you've heard rehearsed by way of oral submission today. Begging questions, global, embarrassing, etc. What you haven't seen there is a positive contrary case. If the third defendant, who goes so far as to suggest we don't have expert evidence, and we do, he goes to say, well, really, that this allegation has been made. If the third defendant's sitting on relevant, and it is the Highway Authority, so it shouldn't be hard for it to obtain the relevant standards applicable, it was entitled to plead them. It was then entitled on its reverse summary application to say either you've got it wrong completely, the bend complies with the relevant standards at the time, these were the standards, or it doesn't comply, but by a matter of whether 1 degree or 3 minutes or whatever it is, that it doesn't comply by such that it's causally irrelevant. It's entitled to promote a positive contrary case in that way. Indeed, one would expect it to if it's going to issue a denial as opposed to non-admission. But it hasn't. So it really echoes, in my respectful submission, the observation of my Lord Justice Dingemans, the effect that not only is there an obligation on both parties, but if you bring your reverse summary application, and that's really what your complaint is, you're going to the substance of the complaint. You're not going to the pleading point. You're complaining about the substance of it. You just don't like it. If you've evidence to say that it's misconceived, factually, so be it. Make your application with evidence. But if you don't make an application with evidence, I do not understand the basis upon which it's said, other than this, one understands as a matter of good sense, in order to persuade a court and so forth, one can take the view, well, all right, I'll introduce my own evidence. But this does give rise to what's a perennial problem, the same with interim payments, which is the route by which parties obtain unilateral disclosure of the other party's expert evidence. It's a well-worn device to do so, unfortunately, when normally that is a matter which comes after disclosure, after exchange of witness evidence. You then get to the exchange of expert evidence.
Yeah, but that I well understand that point as a matter of personal injury practice. But on the other hand, it's normally against a situation where you have a slightly more detailed pleading, and one which doesn't plead every cause of action which might possibly be relevant.
My Lord, as I've respectfully submitted yesterday, that point can be taken, but only so far. So far as concerns this court's role in managing civil justice. This court is, of course, A, entitled, and B, may well be disposed to make its observations for the benefit of those conducting civil justice generally. But so far as concerns this appeal, I'm afraid it doesn't touch upon where we are, because the allegation was there. Indeed, my learned friend would say, well, I effectively recognised it in my skeleton argument, and that it was there, so it was there before the judge. It's then put against me in fairly strong words. I think that it was spurious to raise ground 9. Ground 9 is based, and you can see this, I've taken you to appeal bundle page 68 in the judgment of the judge, when he says, I reject this, see Kane, which doesn't assist. I took the court through this yesterday. It's page 68. It was a little bit harsh to describe ground 9 as spurious in those circumstances. This was your lordships will recall at the top under 26A4. The learned judge says, on the fact that the highway authority created the danger, and I turn to that issue and reject it in the next paragraph. And he does so by saying, I'm going to look at Kane, and then right at the bottom, I fail to see how this decision supports the case alleged. That on its face, and once, of course, all these judgments are always open to interpretation, but imagine if we hadn't made the allegation at ground 9, then it might be turned against me, or whatever concession D3 may or may not have made, below as well as here. This is the finding of the judge. There isn't a claim on that basis. So far as the introduction of the Bolam test, first, that doesn't make an appearance in the defence. Doesn't what? Make an appearance in the defence.
Right.
It does not make an appearance in the skeleton argument below, I think, and it doesn't make an appearance in the skeleton argument on appeal. It makes an appearance orally for the first time today. Operating in the world of clinical negligence, as many of us do frequently, we don't plead allegations against medical professionals on the basis that it's being put at all. I never have done. I've yet to be criticised for doing so. I plead it, if you like, as if it's a road accident, because that's an issue which goes to proving your case. You allege your case. The hospital, through its servants or agents, was careless in the following respects. Heading, particulars of negligence. 1, failing to take the following step. 2, causing X, whatever it is in a clinical negligence setting. We do not describe the Belitho test now, really, rather than Bolam. We do not describe the doctor failed to conduct himself in a way consistent with a reasonable, rational, or responsible body of medical opinion operating itself in a logical way, which is effectively the Belitho test. We don't plead that. We are not required to plead that. We simply, I don't know in the world of commercial, professional negligence and so forth, it's not my arena, what one would choose to plead against a designer and so forth in terms of reference to the Bolam test, but it's certainly in the world we inhabit, that has never been necessary and never been deemed to be necessary. I know of no case that suggests it is, and none's been put before the court. And so that, respectfully, again, simply doesn't add to the position at all. So what we're left with is no adduction of evidence, save, and I'm slightly intrigued as to the thrust of my learned friend's submission taking you to heart, which there does seem to be an undercurrent to his submissions. No, I'm not showing you heart to say they've got the guidance wrong, but I'm kind of showing you heart and I'm making some commentary in relation to my concerns about the validity of the claimant's case. So it's somewhat underhand in its approach. That's its effect. It's very unfair. The issue goes back to the core issue of let's look at the pleadings. And we have pleaded a breach of duty, of the common law duty of care, caused the accident. And that suffices in the ordinary way. And there can only be one answer to that question. It isn't an issue of discretion. See the observation by Lord Justice Lewison. It's not an issue of evaluative judgment insofar as the term evaluative judgment, which can be employed in different circumstances, is supposed also to say, well, it's evaluative judgment rather like a discretion in which there's a range of reasonable opinion. It isn't, because you are dealing with the hard-edged issue of denying a claimant a right of access to the court. And there, you don't get to turn up in different courts and find that you have a right of access in some and not a right of access in others.
Not sure about that.
In my submission.
Well, suppose that you fail to comply with some order and a sanction takes effect and you apply for relief against sanctions. If you don't get it, you're denied your access to the court, but that's plainly a matter of discretion.
My lord,
so the mere fact that the effect of the decision, whatever it is, brings your claim to a premature end does not of itself mean that the discretion is a binary, is a hard-edged question to which there can only be one answer. I mean, I take your point that this isn't a discretion, and it's probably not an evaluative judgment in the sense in which that expression is often used, but I don't think you get much more support from relying on access to the court.
Well, your lordship makes a powerful point in relation to the outcome can be achieved by exercise of discretion, which requires me to focus back on what it is that the court is doing, and the court isn't weighing and balancing.
No, I understand that.
And that perhaps is the essential point.
Does this pleading plead enough to raise a justiciable issue as against the third defendant?
My lord, yes. And put in that way, one can see in my respectful submission how that is a binary issue. Yeah. Does it plead enough? It doesn't lead
not necessarily dissenting from that. I'm just saying you don't get any extra help from access to court points.
Your lordship's perhaps exposed the weakness in that submission, or rather too effectively. So I see that, my lord. My lord, may I turn please now to D1 and D2?
Yeah.
My lord, I don't really wish to introduce evidence, but the whole is it darkness thing, there's a police report which was obtained for purposes of the inquest, and it actually indicated the accident was at 8:53 p.m. and that sunset was at 21:03, as opposed to the 8 p.m. which is referenced. But I don't think that's dark, that's just before dark.
So you're not going to adduce any evidence, but you're going to give evidence by way of submission?
Well, it's probably just an exercise in defensive mechanism for having said it's at night, which sounded a bit random when it was then.
Well, if it was a reverse summary judgment, then frankly the police report should have been exhibited by someone. Yes. And perhaps as you've gone through a full inquest and someone had tried to work out what had happened with the unfortunate to the unfortunate deceased, it might have been helpful to have had those notes, but we don't.
My lords, can I start with section 11A? And first of all, the submission, obviously I'm referencing principally the submissions of Mr. White, because he took the lead in relation to issues. No disrespect to learned friend for the second defendant. He drew a distinction between danger and risk. That was early doors. The difficulty with that submission is one that I've sought to sort of draw out by reference to the wording of the 57 Act and the 1984 Act, because the 57 Act does not use the word risk. It uses the word only danger, danger due to the premises. It would certainly be, it has been my submission, if implicitly, if not explicitly, that the court would be expected to use or to understand the word danger to carry the same meaning in the 57 and the 84 Acts. It would certainly be somewhat surprising if it were not, if that was not Parliament's intention. And so the 57 Act, which doesn't use the word risk, it invites what I've already described as, if you like, the ordinary meaning of danger, which is risk of injury. My Lord, it's page 4, Authorities Bundle, page 4, section 1.1 of the 57 Act. So at the top, the rules enacted shall have effect, I'm missing out a few bits, to regulate the duty which an occupier of premises owes to his visitors, and it's quite simply, in respect of dangers due to, and we know it carries on after state of premises, but again I'll foreshorten it, so in respect of dangers due to the state of the premises. And that incorporates risk of injury. That's what danger is essentially meaning, and that's why I was labouring this mission, that normally I would say you're going to have the same meaning. It does give rise to this tautology that it becomes a risk in respect of a risk of injury. I think that's just an unfortunate drafting feature because of the parliamentary intention to show clearly that we are concerned here with risks of injury to person only. That was my submission. I'm not holding to it, but that's my understanding, so that one doesn't then break it into two parts and now say, well, danger for these purposes no longer means risk of injury, so there's a risk, but the risk and the danger may not collide. Furthermore, when one goes back to Lord Hoffman in Tomlinson in the key sections of his judgment, so that's Authorities Bundle, page 245. Your Lordship sees at paragraph 26, and just while we're here, immediately can I re-emphasise that point? He is not looking at is there a danger. He puts a danger, open inverted commas, due to the state of the premises. That is entirely his focus, is what I call the causation issue.
Well, I mean, that's the statutory wording in the 57 and...
No, I understand, my Lord, but he would have put open inverted commas, danger. If the whole thing was just about danger, he would have put open inverted commas danger, or if it was about danger due to the state of the premises, he'd have put open inverted commas danger due to the state of the premises. He says a danger, and he then focuses on due to the state of the premises.
But I mean, the 57 Act has with it, I mean, if you were going back to that, the well-known distinction between dangers due to the state of the premises and dangers due to activities.
My Lord, yes, but we've got to keep...
And that's what Lord Hoffman was really doing. He's just tying it into the danger due to the state of the premises rather than a danger due to what you're doing on the premises.
Well, my Lord, the due to what you're doing on the premises part is this danger of when one says occupancy is against activity, of always maintaining clarity as to whose activity.
Yeah.
The occupancy against activity duty references the defendant, not the claimant. When we say the Occupiers Liability Acts are not concerned with activity duties, we mean by the defendant. We don't mean by the claimant. Tomlinson, in these paragraphs, breaks the causal link, the obvious causal link that exists in all these cases, including this case, naturally, between the danger and the state of the premises, because the drowning has occurred in the reservoir. In very particular circumstances, now looking at the claimant's conduct, highly unusually. So it's not the distinction between occupancy and activity duties in that way. It's a distinction drawn focusing...
If that's right, it's rather odd that Lord Hoffman at the end of paragraph 26 appears, to me at least, to agree with Lord Phillips that Mr. Tomlinson suffered his injury because he chose to engage in an activity, etc. And the important words are not because the premises were in a dangerous state. And then he says in the next paragraph, just by letter C,
Yes, my lord.
in neither case can the risk be attributed to the state of the premises. And then he says, otherwise any premises can be said to be dangerous to someone who chooses to use them for some dangerous activity. So that would be the ordinary roof of a dwelling house, which is one of the examples you gave. Of course it could be
my lord,
dangerous, you could fall off it, but that doesn't seem to be the way that Lord Hoffman sees it.
my lord, respectfully, I read that entirely differently. May I just for one moment park that, just to go back to the beginning of para 26. Beginning of para 26, Lord Hoffman says the first question, therefore, is whether there was a risk within the scope of the statute. So he's got a heading, danger due to the state of the premises. He chose not to put in risk arising out of danger due to state of premises, and he's immediately talking about risk. I identified that at para 29 before, and you see it also at para 28 at F. In my opinion, things done or omitted to be done means activities or the lack of precautions which cause risk. So you have Lord Hoffman clearly equating danger with risk. That's just that part of the submission. I absolutely will address, my lord, the part that your lordship raises. Yep. But that, just to follow that one through, if I may. So as I sought to sort of, that's why I was spending that time on the wording, to compare the wording of the two statutes, because it is possible to say, should I link myself to the risk arising out of, as opposed to the danger due to? But we don't gain from that and say, oh, there's a whole extra special hurdle under the 84 Act, because you're essentially looking at danger due to the state of the premises. That's the heading for this passage, and that's equally applicable to the OLA 57, where danger equates to risk. So, my lords, the next submission is the defendant's case rests entirely, as I follow it, on their interpretation of these relevant passages in Tomlinson, and that what they say are its effect in limiting the scope of Section 11A of the 84 Act. And there seem to be two possible routes, one of which is as per the observation by Lord Justice Lewison just now. One is the idea, is the reservoir not in a dangerous state? The other is, was there a danger, but the danger was not due to the state of the premises? I will take those in turn. My understanding of I mean, it may be the defendant is saying, well, I don't mind as long as I can win under one of them, but the essence of their submission I really followed to be under the second one, that it was an issue of causation. And I say that because, having regard, for instance, to their skeleton argument, that's Mr. White's skeleton argument, if you go to paragraph 8 of his skeleton argument, which is, no, that's not it. It's tab 14, page 142. So down the bottom, in the appeal bundle on page 142, when he says D1's primary point is it's not necessarily appropriate to break down a statutory question in constituent parts. Rather, the court should consider whether or not there was a risk of injury by reason of dangers due to state of premises. There was not. The risk of injury was not by reason of danger due to the state of the premises. It was due to HB crashing off the road, which is what I call Tomlinson causation, which is what I say Tomlinson's really about, not the potential way of reading it as per the observation of this court this morning. And that's causation. And indeed, at paragraph 10, just below that, you'll see he says it is accepted that water of any depth has potential to be dangerous. And there's nothing in potential, because sometimes it's been put against us, you need a latent danger. And in the Vinot case, the Canadian judge uses the description abeyance danger, which I understand to mean effectively it's there in abeyance waiting for someone to come and strike against the pole when it becomes a real danger to them. So I don't think there's anything special about that. Saying it's a latent or potential to be dangerous is just a different way of saying it's dangerous when this circumstance of this case materialise. I haven't really understood that he's actually saying Tomlinson says, contrary to one potential reading, which I will come back to, of my lord, that the water is not dangerous, or the roof isn't dangerous, or the window, and so forth. I believe him really to be focused on the issue of causation. So,
now, just before you leave,
yes,
dangerous,
of course,
just ask this one question, which is, if one is looking at dangerous, the word danger in a normal way, and also then having regard to the old Highway Act cases about some tripping hazards which can trip are not dangerous. I mean, if one's looking then at the state of the premises and danger, the danger was due to the car coming off the road. Is it relevant when one assesses danger to know that no car has ever come off the road into the reservoir for 54 years?
Not at all, my lord, no.
Why is that?
Because it's not the whether or not Mr. Vinot was the first person to go down the snowy route isn't relevant to the prior question of is there a danger due to the state of the premises. Whether or not this is the first person who's fallen into a pool at someone's house isn't relevant. That all comes later. It comes when one is analysing either the 57 Act breach issue, or we've got foreseeability deeply tied into Section 1.3 of the 1984 Act when there were those requirements, whether you can expect anyone to be there at all, whether you understand there to be a danger and people are in the vicinity of it. This is, and would be, but for the Tomlinson add-on, if I can put it that way, this essentially, as your lordship's indicated, objective assessment by route of saying simply, no, you've got a body of water, and that body of water constitutes a danger. Now, it may be that lots of people are at risk or not, but this only arises in the context of a particular claim which is being brought, which will then engage all of the facts of the case. But you don't describe the danger somewhat respectfully, bizarrely, by reference to the particular circumstances or route by which that person's got there. The point is much more straightforward. So you have in the Ratcliffe case, as we know, no difficulty by the Court of Appeal at all in saying the water is dangerous. There is a risk to a person who dives, but there is no danger in this premises because no one dives in this pool and no one was expecting to dive. That's a later question the court's going to ask itself. It's not the question it asks itself at that stage. The cob is dangerous in Staples. That's the end of the matter. The low bridge is dangerous in Edwards. You don't have to ask how foreseeable is it that the man will A, use a bike to walk with his bike across the low bridge, and B, for unknown reason, that's the finding of the court below, for unknown reason, lose his balance and topple off the side of it. You don't ask those questions at this anterior stage. In Tomlinson, as we see when we go on to paragraph 30, Lord Hoffman has no difficulty with the concept of there's a danger due to the risk of drowning. And that's why his heading, forgive me if this point isn't sort of getting through, it's my fault, but his whole section of 26 to 29 is not saying there isn't a danger. He's not headed it. Is there a danger? He's heading it a danger, open inverted commas, due to the state of the premises, because he's gripped by the issue of causation. And that's what that whole section is about. But he proceeds apace at para 30, and I took your lordship to the relevant part of para 30, and 30 between A and B, the risk of injury from diving off the beach. It just isn't difficult. There's another case, and forgive me, I've shown my learned friends this morning, called Taylor and English Heritage, which I've put up to the bench. This is
the one about somebody falling down a bank as a castle or something, isn't it?
My lord, it is. It's a decision of the Master of Rolls. That was Lord Dyson at the time, yeah. And any judgment by Lord Dyson merits careful consideration. Sitting as the Master of the Rolls, it's a National Trust site. I don't know if it isn't that. Yes, no, it's English Heritage. Sorry, an English Heritage site called Carisbrooke Castle in Isle of Wight. And your lordships can see from paragraphs 4 to 6 what happens, which is, if you like, it's like a wedding cake in the sense that it's got drops and then flat sections, and then you go up and it's got another flat section. And between two of the flat sections there's a slope. The claimant seeks to go from the higher flat section to the lower flat section, and as you see in paragraph 6, he loses his footing, gets down to the lower section, obviously out of control, and over the edge of the lower section, so described as the bastion wall, down into a moat. The recorder, see paragraph 10, describes as a clear risk to anyone walking along the bastion path because of the sheer drop and the absence of any safety rails. And although this is a 57 Act case, one can immediately see here you've got someone who's inadvertently found themselves going down a drop to a moat. Now that's materially equivalent to falling into the moat which was there in a pool of water at the time, in the sense of trying to understand the landscape of this compared to...
Duty wasn't ever an issue in this case, anyway.
Duty was not an issue, but when one goes through the analysis, the recognition by the master of the rolls, who would not be shy in coming forwards if he considered that he was supporting an incorrect legal analysis. Paragraph 21 says the opposite. Just like Staples, he says, right at the end of 21, the sheer drop was not an obvious danger. It was all about, was the danger obvious? The danger wasn't obvious, and the defendant ought to have taken reasonable steps to protect the visitor. In other words, it's actually key to the whole assessment that there's a danger. The issue in the appeal was the danger obvious? So it's not that it sits there as an unappealed point. It sits there as a critical point in the reasoning of the court. See para 24. The risk of falling 12 feet down a sheer drop was a different order of magnitude. It involved a real and obvious risk of serious injury. Para 24, my lord. Right in the middle. Sorry, it's difficult when I jump around, but right in the middle of 24. Of course, that was again a case that involved a finding of contributory negligence, as one would expect, which is how the court manages these issues. There's also an interesting passage which I would invite the court to read, from 28 to 30, in which, although there was a finding of liability in that case, here we're just seeking to pass the strikeout threshold, but here there was a finding of liability, and what was raised against the claimant were, as Lord Dyson properly described them, in terrorem arguments. What will this do to English heritage and other occupiers of premises, and the concerns which I sought to meet face on yesterday, because I understand those concerns. And you see how Lord Dyson is very phlegmatic, if I can put it that way. See paragraph 30.
Yeah.
But we're at a strikeout stage where the court doesn't have to be so concerned. We're not having a finding of liability at this point in time. So there's a case where, again, yes, a sheer drop that has no barrier is a danger. Do we have to ask how many people have fallen off this? How many people went down the grassy slope, slipped and fell off before? No, we do not. It is a danger. I think it's accepted, and I've shown you reference in the case law, that a pit in the ground is danger. Well, a pit in the ground that's filled up of water is a reservoir. I mean, the distinctions the court would have to seek to make are quite extreme. I gave my examples yesterday in relation to flat roofs, swimming pools, and so forth. The court put to me, so as obviously to test my case, where are you going with this? Really, what, to a staircase in the RCJ? That's why we have balustrades. Why they exist, my lord? Because there's a risk of falling off the side of staircases. That is why they're there. If you have a staircase at home...
No, I think the question was being put not on the basis that if you didn't have it balustraded, it was on the basis that it is balustraded and still complies with all the relevant safety features. There's still a risk of danger.
There can be risk of danger.
Yeah.
We then quite swiftly can move into the Tomlinson world, because you have to ask how that person has managed to injure themselves. And there's a case called Gore which involves a banister, and where the claimant chooses to slide down the banister as an act of entertainment. then Mr. Justice Coulson, as he then was, had little difficulty in applying Tomlinson.
Yeah.
It was a Tomlinson case. But my point that I keep rehearsing, my lord, is that's what a Tomlinson case is. A Tomlinson case isn't, can I read into paragraphs 26 and 27 that there is some ratio that lies within Tomlinson that these premises are not dangerous. So if we go back, my lord, please, to Tomlinson and to what's actually said, and if I pick it up where your lordship did, so I'm going to start at the bottom of 245 on para 26, where he introduces the Donohue Judgment. Donohue, of course, was about section 1.3. These were obiter comments by Lord Phillips. He says, in Donohue, Lord Phillips expressed this opinion. He said, etc., and I'm not going to read it all out now, that isn't approved. I mean, I understand one always can read these judgments that, oh, read in context, it means this or it means that. But he doesn't say in terms, I approve of this statement. He says, in making this comment, the Master of the Rolls was identifying a point which is, in my opinion, central. And he then goes on to elucidate his point. That's para 27, which I will go to. But I don't see that as in terms saying that. I also read the statement from the Master of the Rolls, where he says, it seems to me that this is the end of 26, my lord, it seems to me that Mr. Tomlinson suffered his injury because he chose, emphasise that word, to indulge in an activity which had inherent dangers, not because causation, the premises were in a dangerous state. In other words, it's not inconsistent with the premises are in a dangerous state, but this is a case in which the claimant's injury is a product causation has been caused by what Lord Hoffman is about to explain is the exercise of the claimant's free will to perform an activity with inherent danger, which danger materializes. So I read it by emphasizing the because part, not by reading it saying he is saying the premises are not in a dangerous state. It's about causation. It's always about causation. Does your lordship see that submission?
I see the submission.
I don't understand, my lord, that whether your lordship's persuaded or not. It's a matter for your lordship, but at least to know that the court has.
No, I quite understand. You say that the reservoir was a danger. There's an obvious danger if you fall in and drown.
Yes, my lord.
And once you get past that hurdle, you're then on to the question of causation.
Yes,
and that's a question which can't be decided on a strikeout.
Well, my lord, it can't. Either it can't be decided on a strikeout, or it can be decided quite easily on a strikeout because she was an inadvertent trespasser. So we are nowhere near Tomlinson. Tomlinson, as I say, the word exceptional is sometimes not encouraged by the courts because it then leads to arguments, but do you mean special circumstances as opposed to exceptional? But there are special circumstances to Tomlinson criteria, very special circumstances. We know they are. It's led my learned friend to have to say, oh, paragraph 44 is obiter dicta. It is obiter dicta, but it's obiter dicta in relation to the central issue. He says so in para 44. Second consideration, namely the question of whether people should accept responsibility for risks they choose to run, is the point made by Lord Phillips, in which I said was central to this appeal. It's of a piece with his para 27 analysis. The two run together. It is obiter because he's looking at section 1.3c, but it is absolutely the same point.
Which sounds as though he approved it. As you said earlier, he didn't.
My lord, the identification of the point by Lord Phillips, the identification of the point is it's an issue of responsibility for risks you choose to run. He isn't saying that the identification of the point is Lord Phillips is saying premises are not in a dangerous state. He's saying Lord Phillips has identified a key issue of causation.
Yeah.
And that's always his focus. And so when you go to para 27, again, it's forgive the any latent sense of frustration on my part, but it is literally a case of my reading a sentence with potentially a totally different understanding of what it is meant by it to the court, which can be frustrating, but I must hopefully not show that. So, my lord, if you go to para 27, he says, in making this comment, the master rolls identifying a point which is, in my opinion, central to this appeal. It's relevant a number of points in the analysis of the duties, which is why it's relevant to his paragraph 45 part as well. It's the core point for him. And then his next sentence, Mr. Tomlinson was a person of full capacity who voluntarily and without any pressure or inducement engaged in activity which had inherent risk. That is the Tomlinson case. That is what it reduces to. The risk that he might not execute his dive property was that he might not execute his dive property and so sustain injury. Likewise, a person who goes mountaineering incurs, like it chooses to incur, the risk that he might stumble and misjudge where to put his weight. In neither case can the risk be attributed to, causation, critical, attributed to the state of the premises. It is an issue of, as I made my submissions yesterday, attribution, or I've called it causation. It's the due to. And then he says, in that context, otherwise, any premises can be said to be dangerous to someone. And you can't stop there and say, he's saying it's not dangerous. No, he's saying, otherwise, any premises can be said to be dangerous to someone who chooses to use them for a dangerous activity. So he's not saying the premises aren't dangerous. He's saying anyone can then say the danger is due to the state of the premises, but it isn't. It's due to the activity he's freely chosen to perform. And I hope, my lord, that sets out
why I quite understand.
Why I respectfully resist any other interpretation of paragraph 27.
Yeah.
You were taken to the judgment of Lord Hutton, and Lord Hutton's judgment, after he recognises that on the facts of that case there was a danger, he moves on, this is page 253, he moves on at para 56 to say, let me please look at section 1.3c. Does your lordship see that? And then follow his reference to Scottish authorities. And the Scottish authorities 57 and 58, if I can go into between D and E, recognise that premises, including natural features of premises, are dangerous. So he says the situation of a town on the banks of a river is a familiar feature, and whether the stream be sluggish, like the Clyde at Glasgow, or swift and variable like the Ness at Inverness or the Tay at Perth, there's always danger to the individual who may be so unfortunate as to fall into the stream. So he recognises the danger, or the learned judges in those cases do. They just say, we don't think you should be liable. That's where Lord Hutton takes himself to, because he makes a finding that, which comes right at the end, at para 65, that section 1.3c is not satisfied. That's the, is it reasonable to impose a duty of care?
And that is not something that's ever going to change before or after a trial. I know you say that once you're into 1.3c, that's not a strikeout point. But why? Because, I mean, Lord Hutton says, well, the common law since 1908 has been like that. And you're saying, no, let us go to trial, we might get an accident expert, etc.
Yes, my lord. Can I, forgive me, may I just...
Yeah, of course.
Pursue exactly what he's saying, because here he's looking at streams at 57. Then he references a case called Glasgow and Taylor at paragraph 58. And then he says, Lord Shaw stated, grounds thrown open by a municipality to the public may contain objects of natural beauty, say precipitous cliffs or the banks of streams, the dangers of the resort to which are plain. So here again we have a cliff represents a danger. It doesn't give this court tremendous difficulty. It's obviously dangerous. Just like in Taylor and English Heritage, you've got to drop down to the moat. It's like a little cliff. It's obviously dangerous. There isn't a problem with that. But he then goes on and he talks about, in that context, this is Lord Shaw talks about between G and H, and he says, rather he had in mind in measures which the common sense of mankind indicates as being unnecessary to take. And then he continues, there are certain risks against which the law, in accordance with the dictates of common sense, does not give protection. such risks are, open inverted commas, just one of the results of the world as we find it. So there, and then if you actually go over the page, just to make good the clarity with which he's recognising that these natural features are dangers. If you go over the page between A and B, they express a principle which is still valid today, namely it's contrary to common sense and therefore not sound law to expect an occupier to provide protection against an obvious danger on his land arising from a natural feature such as a lake or a cliff, or to impose a duty on him to do so. And then para 60 references a case called Cotton, where someone has fallen off a cliff and he says, no duty to provide protection against dangers which are themselves obvious. So the first part of this is, there is a recognition that all of these features, staircases, roofs, windows that can be opened, pools, streams, cliffs, and so forth, the dangers, there really shouldn't be any difficulty for the court in relation to that issue. To then say, because we have a judgment of Lord Hutton, which has sought to apply some very old case law based upon natural features and the common humanity test, in the circumstances of Tomlinson, which are quite different from this case, because he always has to have regard under section 1.3 to the circumstances of this case. He is obliged to do so. He's having regard to an individual, as so clearly made apparent from Lord Hoffman's judgment, who has elected to dive into the pool. So what he actually says at 65 is, therefore I consider that the risk of the plaintiff striking his head on the bottom of the lake was not one against which the defendants might reasonably be expected to offer him some protection. And so that cannot be applied across in some sort of straightforward fashion, respectfully, my lord, to the facts of this case. And that's my response to that question. What happens is we're back to all the circumstances of our case, which are materially different, and this question of whether or not in those circumstances, where there's an inadvertent trespasser, having no intention, not that she wasn't in that sense playing around by the water's edge, dancing up and down a wall on the water's edge or something of that nature. It's much more akin, although it's a 84 Act case as opposed to a 57 Act case, it's much more akin to that Taylor and an English heritage case, because there's this, what happened is he slipped away from the edge. He didn't slip on the edge. He slipped down the grassy slope that was coming to a flat walkway, to the other side of which there was the drop to the moat. So it all happened over here. His inadvertence, his carelessness, which is 50% to blame, happened here. The consequence of which was he then slid all the way down across the flat surface and down the drop.
But there was a distinction. He'd been invited to walk there, yes. And the deceased hadn't been invited to cross the barrier. Oh, my lord. We're 84 Act case. Yeah. That's and drawing distinctions in cases is easy, surprisingly easy. My lord, yes. So what we are left with is a very specific application of Tomlinson, what I'm calling the Tomlinson test or approach or whatever. And when one goes to the cases that are prayed nay, because there is no case, if you don't, unless you read into those paragraphs in Tomlinson, entirely contrary to my submissions, there is no case that supports the submission that my learned friend seeks to make, which says that this applies regardless of what your personal intention was to anyone who inadvertently has found themselves a trespasser, just as much as those who intended the outcome or knowingly bore the risk. No case at all. What you were taken to in support was, first of all, Donohue at paragraph 33, which is at page 176. And Donohue, as I've submitted already, was a case under section 1.3, and para 33 is concerned with section 1.3b. It's not concerned with this issue at all.
This is a paraphrasing of section 1.3b. It's para 33 at page 176. And if you had section 1.3b of the 1984 Act with you at the same time, which is on page 12, you'll see this is a paraphrasing. When he says, where the state of the premises constitutes a danger that's perfectly obvious, in other words, there is a danger, and there's no reason for a trespasser observing it to go near it, a duty under the Act is unlikely to arise for at least two reasons. And he says the first is that because the danger can readily be avoided, it's unlikely to pose a risk of injuring the trespasser whose presence on the premises is envisaged. That's 1.3b. You're not expecting that person to be in the vicinity of that danger. And then he moves on to 1.3c. I take that to be his second reason. He says there are circumstances in which it may be foreseeable that a trespasser will appreciate that the dangerous feature poses a risk, but will nevertheless deliberately court the danger. And then he says, it seems to me at least where the individual is an adult, it would be rare that those circumstances would be such that the occupier can reasonably be expected to offer the other some protection. That's 1.3c. Keown. Keown is a Tomlinson case. Keown, per Lord Justice Longmore, at paragraph 12 at page 304. So picking it up just above E, if I may, Mr. Keown was 11 at the time he decided to climb the fire escape. The judge's finding was at paras 15 and 42 that he appreciated not only there was a risk of falling, but also that what he was doing was dangerous and that he shouldn't have been climbing the exterior of the fire escape. In these circumstances, it cannot be said that Mr. Keown did not recognise the danger, and it doesn't seem to me to be seriously arguable that the risk arose out of the state of the premises. So there again, we've as it happens, collapsed the rather lengthier statutory form of words, but because it doesn't really seem to matter whether you say the danger wasn't due to the premises or you say the risk didn't arise out of the premises, because there seems to be an interchangeability in relation to this. But that is a determination based entirely on attribution or non-attribution, if you like. Ditto with the judgment of my Lord Mr. Justice Lewison, as you then were, at paragraph 29, and I've read out that sentence, the last sentence. The only danger arose from the activity of Mr. Keown in choosing to climb up the outside, knowing that it was dangerous to do so. That's the ratio. That is a conventional application of Tomlinson.
Yeah, no, I understand that, Mr. Weir. I don't want you to repeat all the submissions you made in opening. This is your chance to reply to the submissions
yes,
of
your Lordship,
your opponents.
Your Lordship's right. May I just go to the other cases, because I was keen to get to expose that there aren't any other cases. He referenced a case called Grimes, on which I hadn't made submissions. It's a first instance case. Grimes is relevantly here at page 352. This won't take...
352?
352.
Yeah.
Grimes is another case of swimming pool. It's a case of a young adult who dives into the shallow end of a swimming pool. And if you kindly go to page 359, para 48, she said that it was dangerous to dive where the water depth is unknown. The obvious danger, as she recognised, was the risk of hitting her head. If you then go on to page 364, paragraph 76, there's always a risk in swimming and diving in any pool, i.e. they're dangerous. Last part, every adult of normal intelligence knows it. The claimant in this case knew it. That's a reference back to paragraph 48. Over the page, paragraph 83. After going through Tomlinson, last part of paragraph 83. That is correct, but I cannot ignore what Lord Hoffman described at paragraph 44 as the central reasoning in his case, namely the freedom of an individual to exercise free will. Bottom of paragraph 84, the sentence that you weren't read out, you read out the last one, but that's the one before that. The claimant's position cannot be distinguished from that of Mr. Tomlinson on that basis. It's just another Tomlinson case. It's all about the exercise of free will. Mrs. Justice Thirlwell, as she then was, recognised that.
Well, she did finish off by saying it wasn't unsafe for diving, even though he'd ended up.
My lord, yes, but that's because we've had Keown by that stage, and so I don't wish to labour that issue, but we've had the potential for confusion in relation to additional features which are not apposite. So far as concerns the submissions in relation to section 1 bracket 6a, first of all, apologies to the court. In answer to my Lord Justice Dingemans, I said, well, I didn't think the 57 Act has anything to say. The 57 Act does have something to say, and it seems to provide the answer very much in line with my learned friend's submission, so I should take you back to that. Apologies, page 4. They're in your authorities bundle, page 4. And it's section 1 brackets 4. A person entering any premises in exercise of rights conferred by virtue of section 2.1 of the 2000 Act is not for the purposes of this Act a visitor. And so I think that's why we've then found ourselves in the Trespassers Act.
What about somebody exercising a private right of way? I mean, it doesn't arise on the facts of this case. I'm just curious. Are they a visitor or?
Oh, private rights are terrible. Whatever. There's a case against Northern Ireland.
Oh, don't worry. It's a really
real problem area.
The Milkman case, wasn't it?
Yes, and my learned friend is amongst other things a highway specialist. Could probably give you a sort of chapter and verse. But
all right, if I want to, I will indulge my own curiosity.
My lord, yes. There are distinct problems because you can be walking along what you think is a highway and you're on someone's private drive. You got all sorts of issues like that.
I wasn't thinking of that so much.
I'm sorry.
If you actually were entitled to a right of way over somebody's land, are you a visitor or not?
I think if say you've got a landlocked house and you have a right of way to get to your house, but you over land you don't own.
You had a license or easement, and that I think was all converted by the 57 Act.
I think that's right, because there's a Court of Appeal case which was quite brutal in relation to a claimant's claim, because they look back at, as exactly as Lord Justice Dingemans says, you have to actually go back to the old law to see who were visitors and who were occupiers under the old law to come within.
Yeah, all right. Thank you.
It was then said against me, well, my submission in reliance on that which was put into the 1984 Act can't be right, because if that was right, then fences, gates and walls would also have to be dangerous. But I don't have any difficulty with these submissions. If you look at what 16AB says, it anticipates that. It's page 12. It says no duty by virtue of this section to any person in respect of B, a risk of that person suffering injury when passing over, under or through a wall, fence or gate. And those keen on exercising rambling rights will know that not all of the gates are well maintained, not all of the walls are well maintained, and that all of these things can involve risk of injury in some way. There's no particular difficulty with that. He references a decision at first instance in Northern Ireland, which is to the effect the fence over which the child got spiked can't be dangerous. A fence can be dangerous. The point is that how you get yourself spiked onto that fence may give rise to the Tomlinson case, and that's what happened in that case. But it may be that you have land, you know lots of people are walking right beside your land, and that there's a drop, and you've got a wonderful fence with sharp points on the end. So effectively, you've got spikes in the ground, and that's the essence of it, sort of Anglo-Saxon style, waiting for someone to deposit themselves on by falling down. That would give rise to an issue. It doesn't mean there is a duty under section 1.3, but it's certainly a danger. That's the point. It's a danger due to the state of the premises, which comes more live there in that context. My lords, as to sections 1.3c and 4, which run together, and as to the perceived unfairness of imposing a duty upon D1 in particular, as opposed to D2, may I make two short submissions, and then I'm done. The first is to take you to the pleadings to show you that D1 was responsible for maintaining the fence.
And then was paid money back, yeah.
Yes, it's not to describe it in sort of conclusory terms, ergo, they're liable. It's to do away with any misconception that they're simply running their show from a premises a mile away, and really it's all quite extreme that anything else should be suggested against them. We've got D1's defence at page 88, and clearly already observed from the Lord Justice Dingemans, but I'll give you the references right at the top. So it's 12D. It's admitted that the first defendant repaired the fence on occasions under a management agreement with the second defendant, but it didn't form part of the demised premises. And if you kindly go to D2's defence, this is at paragraph 8, page 99. There are two parts. It's 8D1 and 8E. So 8D1 says it's admitted and averred that by an agreement in March 2001, the first defendant agreed to manage various of the second defendant's properties, including the reservoir, and at E, it's admitted that D2 constructed the fence. The first defendant is and was at all material times responsible for the maintenance of the fence pursuant to a management agreement. So D1 was intimately involved in the relevant part, and D1 and D2, I maintain, should run together in this relation. The second point that was made was in support of both D1 and D2 was, well, it's really an issue between the claimant and the highway authority. And I've already made my submission that that's all part of the circumstances of the case the court would have to weigh up. Can I just take you to the particulars of claim, in which, for the avoidance of any doubt, the following was pleaded. This is at paragraph 19H, page 80 of the appeal bundle. Failed to consult adequately at all with any of the other defendants and or any regulatory body as to the implementation of adequate measures to ensure motorists were warned and or protected, etc. In other words, part of the allegation, if you like, of what they should have done is, to the extent that a different route was there to them, to encourage the highway authority to itself use its statutory powers. And it may be that had it chosen to do that, it would have complied with or the relevant duty under the 1984 Act. So it's not enough for it simply to say, oh, well, it's a matter for the highway. If you know there's a big problem just off your premises and people lying on it, and you know that step hasn't been taken by another, it could be another landowner, but here in the context of the highway authority, it may be that what you need to do to act reasonably is to invite them to sort the matter out. See Kane, which was a classic case of that, but not happening. That was you needed to make sure that the developer got on and cut down the vegetation and like, and they didn't wait for that. And on the issue of expert evidence, it was said, well, expert evidence isn't necessary, just as it wasn't in Little. But it was Little that I referred to, in which expert evidence from 2 experts was called, and the reference for that, 'cause I never took you to it, was paragraph 24 at page 445. That was one of them whom was an expert in risk assessment. And in Tomlinson itself, let's give you this further reference if I may, Lord Hoffman at paragraph 30, page 247, refers to expert evidence that had been adduced at trial from an occupational health and safety physician.
Yes, but experience shows that quite a lot of that expert evidence, and I think this was just the point that was made by Mr. Panton, doesn't really take you very much further. I mean, sometimes it can and sometimes it can't, but there's nothing that it would indicate this case would be an exception to that.
Oh, well,
I mean,
however weary of the litigation process sometimes and how it's conducted in the trenches, and whatever the force of the Little and Middleton dicta from Lord Justice Stuart Smith, that it's trial by judge and not trial by experts, and experts can trespass into that arena, I don't think one needs to take quite so dismal a view in relation to the available opportunity for expert evidence. It's always a matter for the case managing judge as to whether to give permission, and that submission can be made at the case management hearing. Expert evidence is not necessary in this case, and it will so be addressed, my lord. But the point is, it's all to be done. And the court certainly shouldn't, in my respectful submission, prejudge that case management decision by a sort of broad brush. Well, I'm sure it isn't necessary. That wouldn't be fair, in my respectful submission. Well, I'm very grateful for being given that extra time, my lord, and those are our further submissions.
Thank you very much. Well, thank you very much to all of you. I should say that you have a right to reply on English Heritage and Taylor, Mr. White, if you want to.
Well, thank you. I will take that opportunity. As I stand, can I also make sure that you understand the point that I was referring to yesterday about Liddell was Liddell and Middleton, not Liddell and Bristol.
Okay, sorry.
So it's Liddell and Middleton, which you don't have in your authoritative bundle, that's often cited in support of the proposition that it's trial by judge and not trial by expert. That was the point that I was making, rather than referring to the Liddell and Bristol case here.
Right.
I make 2 points arising from English Heritage, Ms. Taylor. You will recall that yesterday I suggested a theme running through the cases to which I took you, that we were looking for either something defective or something in the nature of a latent defect before drawing the conclusion that was a danger due to the state of the premises. Taylor is another case that supports that proposition, because what there is something latent. In this case, it was agreed that there was a danger. It was agreed that signage needed to be put up because the defendant had in fact put up some signs, just on the judge's finding not enough. And the vital point in this decision is that Mr. Taylor couldn't tell that there was a problem that he was about to encounter because he couldn't see it and there weren't sufficient signs there. It's another latent or hidden problem case, even ignoring the fact that it's a 57 Act case and not an 84 Act case. And just to be clear on that point, I've suggested that when there is a danger due to the state of the premises, the authorities suggest either a defect or a latent problem. I am consciously using the expression danger due to the state of the premises because I'm inviting this court not to pass the statutory test into chunks. But insofar as you do pass, to be clear, I do not abandon the proposition that these premises were not in a dangerous state.
Yeah.
Thank you.
Mr. Moon, sorry, did you want to say anything more about Taylor?
The second point arising from Taylor is that Mr. Weir has invited you to look at paragraphs 28 to 30, where the defendant had used words to the effect of, don't find against us, Judge, because it will have a crushing effect on
the interiorum.
Yes. It essentially is a similar point to that which my Lord Justice Davis labelled as floodgates yesterday. I'll adopt that nomenclature for ease. our case is entirely different as a floodgates concern. That is, in English Heritage and Taylor, we have an accepted duty, only partially complied with, not enough signs. And on the facts of the case, the court was able to say you should have put up an extra sign. If a duty is found to be owed in our case, not only will it be the first case in any jurisdiction that any of counsel appearing before you have been able to find where a knowing but unwitting trespasser is found to be owed a duty, but it will serve to create the risk that Mr. Horn spoke of yesterday, of those adjacent to the highway having to think to themselves, well, on the circumstances of what I've got next to the highway, have I got to do something? Is my tree a dangerous one, or is that bend too sharp? It is a genuine concern that applies in our case that did not apply in Taylor, which is therefore distinguishable for that reason. Unless I can assist with anything further, if you want to deal with the highways, then I'm very happy to, but I suspect that we don't need to.
Mr. Moore, did you want to add anything on English Heritage and Taylor?
My Lord, yes. Mr. White has made my point, as he did yesterday as well, about paragraph 30 of Taylor and the difference between the concern that I expressed at the end of yesterday about occupiers of land near the highway having to assess that land. It's not about liability. It's not about Section 13C. In fact, it's about that bit of Section 11A, which, on the claimant's interpretation, would mean that natural and ordinary features would need assessment, and that assessment is a significant development. I only want to add to that a comment on paragraph 29 of Taylor. The first reason that the Master of the Rolls rejected the floodgates, as Lord Justice Davis put it, I prefer wider implications. But the first, and in fact the primary reason that the Master of the Rolls rejected that argument in Taylor was that, as he said, this case is a straightforward application of existing principle. And our case is, with respect, very different from that. The claimants here are inviting your lordships to take a very narrow reading of the ratio of Tomlinson, sidestep my Lord Justice Lewison's observations in Keown, and do something which Mr. White and I have submitted is impossible to do on a proper reading of Tomlinson, and which the claimants have produced no case where that has actually happened. It is not a straightforward application of an existing principle.
Thank you.
Well, I have nothing further unless there's anything else I can say.
Right, well, thank you all very much. Obviously raises some important issues, so we will take time to consider our decision. You will receive draft judgments in the usual way. That will be your opportunity to correct our English but not our reasoning, and we would hope that in the light of the draft judgments you will be able to agree a form of order disposing of the appeal. If you can't agree a form of order, please make short submissions in writing, and we will make the form of order that we consider to be appropriate. Thank you all very much.